Not a good day. June 29th, 2023, 7:24 in the morning Pacific Standard Time. 24 minutes ago, Supreme Court of the United States had posted something that's going to be affecting every racial profile around, making it harder to get into colleges left and right. Basically, they threw out affirmative action in everywhere, in every place. They bar it, in college admissions at least. So, if you're going to be basing your essays to the higher universities, being that your cultural differences would be adding to the collegiate elite and the academia, you're screwed. Because apparently the conservative court has just decided that being conservative and white is all necessary. Basically, you're screwed. So now media is going crazy over this. If I was a black person, if I was Jewish, if I was Muslim, if I had different colored skin, affirmative action would not guarantee me any admission into college because affirmative action had been trounced upon by Scotus. Basically, I can't do a damn shit. Except fight that much harder trying to get into situations. And right now, people who are trying to get into colleges, at least to higher universities, are going to have that much of a problem trying to get in. Now, I hate to say it, me being white at this point over here, it doesn't exactly help me very much. White, disabled, that's about it. And I can get into the universities if I actually wrote a completely decent essay. I'm struggling with the ones I'm working with right now as it is, as much as old as I am and not quite eloquent in my words on paper. I'm not quite sure if I would be able to be fitting into Stanford, let alone UCLA. Maybe another college closer to home might possibly pick me up if I actually apply for it. If I happen to throw out race into the conversation, would it guarantee me access to a college if I had differences? At this point, SCOTUS is challenging all the college boards across the country and how they're going to be looking at every applicant that comes into their college, whether or not they're going to be adding to the diversity, are they going to be adding to the cultural richness, or are they going to be racially profiling left and right and saying that because you are you and you're not us, you're not welcome? It makes it that much harder for the racially diverse, culturally diverse, basically diverse. As far as I'm understanding this, SCOTUS is really screwed up on this damn thing. They had. And we're not quite sure on how SCOTUS is going to be looking at things for a while. Whether or not we're going to be valuing it. The court case, if you want to look at this at the website for the SupremeCourt.gov, look under opinions. They'll have the current ones, and about third one down, where the date says it's the term year of 2022. The term year would say something about how many court cases they're going to be doing. And they are talking about a lot of them in this past week. Past couple of weeks. They're making their decisions left and right. The case I'm looking at is Students for Fair Admission Incorporated versus President and Fellows of Harvard College. Harvard wins, students suck, and that's how it is. They held the decisions, and it's a thick journal. You want to be specific about it, it's docket 20-1199. It's a good thing I'm not going for legal. I don't think I'd be able to deal with it or stomach it. But right now, all they're going to be talking about is that specific court case. But they didn't even bother to take a look at another court case that actually is going to mean also something more to a lot of people here. Somehow the progressive media picked up on another court case, Counterman versus Colorado. And this is weird. Counterman was one of those people that, if I remember the story correctly, and I'm also trying to pull that information up here too, because Counterman was actually doing a lot of work, greed for help, or actually, here, let me get into the court case here. I mean, I got that information screwed up, so I just want to read what the syllabus is. Okay. Billy Counterman sent hundreds of Facebook messages to a CW, local singer and musician. They never met, and CW never responded. In fact, CW tried to block him, and each time Counterman created a new Facebook account and resumed contacting. The messages well, they had threats of violent harm befalling upon her, on this person here. And it was making CW fear for her life, that she had to do, court filings telling this person to stop it. Counterman actually countersued. And it went through the appeals process all the way up until the Supreme Court heard it. It gets even weirder than that. So making this CW person, vulnerable, Counterman had sued like crazy. There was according to the syllabus, following Colorado law, there were charges against Counterman made by the state under a Colorado statute making it unlawful to make any form of communication with another person in a manner that would cause a reasonable person to suffer serious emotional distress, and does cause that person to suffer serious emotional distress. To quote it from the syllabus. And this is a Colorado statute. Now, Counterman moved to dismiss the charge on First Amendment grounds, arguing that his messages were not true threats, and therefore could not form the basis of a criminal prosecution. Following Colorado law, the trial court rejected that an argument under an objective standard, finding that a reasonable person would consider the message threatening. Counterman appealed, arguing that the First Amendment requiring the state to show not only his statements were objectively threatening, but also he was aware of their threatening nature. Colorado Court of Appeals disagreed and affirmed the conviction. Scotus got it and denied the review. So basically, what they're telling the state is you must prove the true threat cases that the defendant had some subjective understanding of his statements threatening nature, but the First Amendment requires no more demanding a showing than recklessness. Basically, if the guy's nuts or not. If you can show mental instability, then maybe you got a court case. But you got to prove that the statements are just hot air and not threats. Despite the fact, let's just say, I'm going to be a threatener. I'm going to be a threatener. Who am I going to pick on? I'm going to pick on you, the viewer. And I make a threatening view at you. I'm going to do something dastardly. I'm going to say something dastardly. I'm going to threaten something. And you will listen and you will cower in fear. And you will do this because I have the power over you. You will do what I say. And you will do this and you will not sue me. Because I have the power over you. Okay. A characterization. Put that in a context of words. Send that out on social media. If you happen to send it multiple times at this point over here, the law is looking at it in Colorado State and even in California. Is you're threatening with intention. You're threatening to cause harm, even mental harm. But hell, I can keep calling a person an asshole left and right. Oh, you're such a... and go off with the obligatory remarks left and right. Or just downright just tear this person apart verbally left and right. Because. Now, is it because I'm unstable? Is it because I am stable? Is there a possible reason why I'm yelling at this person in the first place? And this is where the legal scholars are going to be having a problem with this particular case of Countermate versus Colorado, because right now we have to prove you're nuts, and you are proving harm, and therefore it's got to go through a stringent process of saying that my threatening remarks on video just now had threatened everybody who saw this and took it out of context. If I'm going to continue to demonstrate that I am totally out of my mind, would this be visually acceptable under Scotus? Or would it not be? Last but not least, Jeff versus DeJoy. Now this one, I'm still trying to wrap my head around this one here. Because somehow there was a legal court case that this particular court was trying to either make a determination specifically or not about religious rights versus commercialism. That's how you look at it. Now, according to this is Jeff versus DeJoy, Postmaster General. According to the syllabus, petitioner Jeff is an evangelical Christian and needs Sunday off for devotion and worship and rest. If you're going to be following religious doctrinations intensely now. Jeff took a mail delivery job with the U.S. Postal Service. A government job. Jeff's position generally did not involve Sunday work, but USPS agreed to begin facilitating Sunday deliveries for Amazon. Basically meaning you're getting your mail delivery through the U.S. Postal System from your local carrier. And you normally wouldn't get any Sunday deliveries, no packages. However, Amazon is a 24/7 operation. They get the orders 24/7. And they have fulfillment centers that work 24/7, but the deliveries only go for a scheduled certain hours. Sundays are those kind of days where a contract had been made between the United States Postal System and Amazon. They changed that. So now this guy who's devout in his religion is forced to work on a Sunday. And he sued. He sued Amazon. Actually, he sued the USPS on this one. Under Title VII of the Civil Rights Act of 1964, asserting that USPS could have accommodated his Sunday Sabbath practice without undue hardship on the conduct of the USPS's business. And they mentioned the court case, and they also mentioned the U.S. Code on this one. And the district court granted summary judgment to USPS, saying the Third Circuit affirmed basis of this court decision in Transworld Airlines Incorporated versus Hardison, which it construed to mean that requiring an employer to bear more than a de minimis cost to provide religious accommodations is an undue hardship. If I am a major employer, or even a minor employer, I am an employer. I am your boss. I am your boss. You work for me. And I am a taskmaster. I know you get weekends off. And Monday through Friday, 9 to 5, you're mine. But now I'm going to diversify my work schedule a bit. I'm going to increase your workload like crazy, and you will do it, or else you will not have a job. I control your future. You will do this because I am your boss and I tell you to. Ah, but you said, no, 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 no. I required this day off. I required Sunday off. Saturday you can try working my ass off, but I need a day of rest. Oh, no, 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 no. I got more people over here doing shifts at this point over here. And you got a rotating shift, asshole. And because you think you're special than everybody else, just because you're some kind of devotee to something, I don't care. You're working that day. But I cannot because my devotion tells me not to. And therefore I will not do that. Well, then guess what? Say goodbye to your frickin' job. But I need this job. No, you don't. I don't care what your family situation is. I don't care what your financial situation is. You need me for your life support, asshole. And you're mine. Okay, granted. A small business guy to a major corporation. Major corporation is telling you that your devotions doesn't matter because you may be doing undue hardship on the business itself. Therefore, they're moving towards the business. And they wanted to get clarification on this ruling of Transworld Airlines Incorporated versus Hardison. And they're indicating that Title VII requires an employer that denies religious accommodations to show that the burden of granting accommodation would result in substantial increased costs of relation to the conduct of its particular business. How is my business going to be affected by you? You're going to be delving into my damn profits. I can't do anything. Private business is one thing, but the federal government is another thing at this point over here. And we have a contract with something else, and therefore we must do this. You want your damn deliveries. We need all the time we can get and all the rotations we can get. So this is a 24/7 situation. You're going to be affecting us in our business. But we have to show on how this is going to be affecting us. How is your religion devotion that much more important to the company profits? How are you going to be a detriment to them? They got to prove it. But they have to do a more specific ruling on this one. They have to tear this damn thing apart because they have to explain that, according to what the syllabus is, this case presents the court's the first opportunity in nearly 50 years to explain the contours of Hardison. The background of that decision helps to explain the court's decision deposition of this case. Title VII of the Civil Rights Act of 1964 made it unlawful for covered employers to fail or refuse to hire or discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges, employment, because of such individual's religion. As originally enacted, Title VII did not spell out what it meant by discrimination because of religion. Subsequent regulations issued by EEOC obligated employers to make reasonable accommodations to the religious needs of employees. Whenever do so would not create undue hardship. However, in 1970, the Sixth Court held that Title VII did not require an employer to accede nor accommodate a Sabbath religious practice because to do so would raise grave established clause questions. And they go over back and forth regarding decisions of different court cases. How the hell is this going to be affecting you? Well, watch your ass go, geez. You make sure that if you're going to be reasonably accommodated because you're a worshiping devotee to something, that it's not going to be affecting the bottom line at all. And if it is, say goodbye to your job. Or you have to go with the flow, boys and girls. That's how I'm interpreting it. But then again, I'm no legal scholar. I'm just reading what Scotus has put out. And sometimes I need a legal scholar to look at this legalese. But this is the stuff that's coming out today. So, have fun with your court cases. Who knows? You may be ending up in Scotus.